everyone. Welcome to the International and Defense Policy Speaker Series. I'm Stephanie Van Platke, the Director of the CIDP at Queen's University. Today, we have two speakers, and I will be introducing them shortly for a special session on war, law, and business. I'll keep the introductions rather short as we want to make the most out of our 1-hour session today, but full bios for the speakers are available on the CIDP website, so do go check those out. Before I introduce the speakers, I want to greet my co-moderator, Sophie Rondeau, who is currently the Senior Legal Advisor on International Humanitarian Law with the Canadian Red Cross. She is a member of the Quebec Bar, a lecturer at Université de Sherbrooke, and an associate member of the Canadian Observatory on Humanitarian Crisis and Action. On to our speakers now. First, we have Fauve Kurnadi, who joined the Australian Red Cross in 2015 and has held the position of legal advisor on international humanitarian law for 5 years now. Fauve's work involves engagement with corporate actors, academics, and university students within Australia. Fauve was admitted as a legal practitioner to the Supreme Court of Queensland in 2013. She was recently named a nominee in Pro Bono Australia's 2022 Impact 25 Awards in recognition of her work, which is at the intersection of business and IHL, with the goal of fostering better humanitarian outcomes in communities experiencing war. We also have Jonathan Kolieb, who is a senior lecturer in law at RMIT University, where he is the Peace and Conflict Theme Lead at RMIT's Business and Human Rights Center. Jonathan has served as legal consultant to the Special Representative of the United Nations Secretary General for Children in Armed Conflict and regularly advises community-based organizations on international legal matters. Jonathan's work has been published in academic journals such as the Australian Journal of Human Rights and the American University International Law Review, as well as mainstream outlets like Foreign Policy and the Washington Post. It's really great that Zoom is allowing us to beam into Australian colleagues. It's bright and early on Thursday morning there, so I do appreciate your willingness to share your expertise with us at the CIDP. I know you've got coffee on hand. I'll now turn it over to Sophie, who will provide some context for the session, and I'll be back to moderate the Q&A after the presentations. Over to you, Sophie.
Thank you very much, Stephanie. Thanks everyone for being there. It's a real privilege to be able to talk about IHL, but also to be among family members. So the Australian Red Cross and the Canadian Red Cross were part of the same movement, the Red Cross and Red Crescent movement, and it's very nice to have activities that kind of connect in that sense. So before I introduce you to the subject of the conference, and I won't take too much time, I promise, because I do want to hear both of our speakers, I'm just going to tell you a little bit more about our international humanitarian law activities at the Canadian Red Cross, and then we'll move on to the subject. So the role of the Canadian Red Cross in Canada is pretty unique. We have a small team of 7 people that are working across the country. One of our main areas, what we're doing right now, we're engaging into humanitarian education and public engagement with academia, university, but also post-secondary student. But we're also doing training and capacity building with the Canadian Armed Forces, RCMP, but also other actors, and businesses is one of the actors we're trying to tackle, and the work of the Australian Red Cross and various universities is very useful in that sense. We also do humanitarian diplomacy and advocacy, so that puts us in a privileged position to organize and participate to events such as this one. So in the next hour or so, we'll be discussing, as Stephanie mentioned, war, law, and business. So we'll be engaged in a conversation about corporate responsibility in international humanitarian law, so the law that specifically applies in situation of armed conflict. And we'll look at what the business and human rights dialogue might be missing at this point. So right now in this globalized economy, it's pretty common for companies to be present in areas of the world that are affected by armed conflict. Those theater of operation, those environments are no longer dominated by military and armed groups. There's also a lot of private actors that are active in those environments, and they have their own rules, their own rights, and their own responsibility. So there's a business and human rights dialogue that's ongoing, and it recently shifted toward looking at human rights abuses. But in the context, attention to international humanitarian law, so a lot of applies in armed conflict, is missing, and it's something that could bring a lot of added value if it's bringing forward. So for the last 4 years, Australian Red Cross and RMIT University, they've worked together to help familiarize Australian businesses with the legal framework that is IHL. So companies that breach IHL, of course, they're causing harm to human life, but there are also other consequences. Those companies might face reputational damages, financial loss, or even legal accountability for the company themselves, but also for the leaders. So it's individual liability that's taken into consideration. So taking the necessary step toward understanding, but also implementing IHL, it will not only help the business mitigate those risks that we just mentioned, but more importantly, it would help ensure that those corporations, they play their part, their positive part in creating a better humanitarian outcome for those communities that are experiencing war. So without further ado, I'll leave the floor to Fauve and Jonathan so we can engage into that fruitful discussion. Thank you very much.
Thank you so much. Thanks, Sophie, for that fantastic introduction, and Stephanie for the very kind invitation, and to Queen's University and the Centre for International and Defence Policy in particular, and your teams for helping bring the webinar to life. We're really pleased and grateful to be with you all this morning, so thank you for joining us. We're joining you from what feels like the other end of the earth. So me in particular, I live in a very beautiful but very small island off the far southeast coast of Australia called Tasmania. You know, Zoom and the last few years have made it possible for us to all be together in these rooms and to talk about some of these issues together. So thank you for the opportunity, and thank you for joining us your afternoon, our morning. Let me just share my screen, and Jonathan and I will speak to a couple of slides. All right. So as is custom in Australia, I'd just like to start by making a short acknowledgement. So Jonathan and I are both joining you from Australia, as I said, and so we pay our respects to the Aboriginal and Torres Strait Islander custodians of land, seas and waterways where we work and where we live. And we acknowledge First Nations elders, past, present and emerging. In particular, I live and work on Palawa land, and I'd like to acknowledge the first peoples of this country, the Muwinina people. So as I said, very, very pleased to be here this morning, but very conscious of the fact, and no one here needs reminding, that as we speak, the war in Ukraine now enters its 5th week of devastation and suffering. There is undoubtedly an enormous humanitarian crisis that continues to evolve in Ukraine, and it continues to intensify, and an urgent and massive response is needed and is going to continue to be needed to meet the needs of those that are severely impacted by the ramifications of this conflict. So today we are speaking about war, law and business, and it seems this conflict in Ukraine has galvanized the private sector to some degree to think much more deeply about their actions in and their connection to conflict and conflict in affected regions. Businesses really have the opportunity and the power not only to mitigate negative humanitarian consequences in these situations, but also to make a positive difference. So if you think about Airbnb's recent announcement to provide free accommodation for 100,000 Ukrainian refugees, for instance. But in order for this to happen, we really need businesses to understand the full spectrum of their risks and responsibilities and to respond to them in an appropriate human rights due diligence sort of way, and to conduct a heightened version of this due diligence in situations of armed conflict. So these are some of the things that we'll be unpacking today. Jonathan will speak to you for probably about 15-20 minutes on the relevance of IHL to businesses and the developing business and human rights movement. I'll then speak to you for about another 15 minutes on the risks and challenges that are unique to international humanitarian law for businesses, and highlight some of the resources that we've produced over the past few years. But firstly, I just wanted to give you a little bit of background and context to the work that we've been doing and the relationship that Australian Red Cross and RMIT have. So as I think Sophie mentioned, Australian Red Cross and RMIT's graduate School of Business and Law have been invested in this work for about 4 years, or just over 4 years now. We set out at the end of 2017 to try to gauge the extent to which Australian businesses understood and integrated international humanitarian law. This included a relatively extensive 12-month consultation period with relevant stakeholders, not just sort of business enterprises, which you'd expect, but also law firms and professional services firms, academics and practitioners. Surprisingly, or perhaps unsurprisingly, we discovered that international humanitarian law was very rarely adopted or even understood by Australian corporate circles. And in many cases, we found it was actually conflated with or replaced by human rights law. So we tried to use these findings to help us shape our response, I suppose, to the gap that we saw in industry, and have since met with dozens of corporate actors, including some of Australia's largest mining companies. We've built guidance materials and training courses, implementation tools, and we've presented to local, regional, and global audiences. I'll circle back to a couple of the resources, as I mentioned a little later in our presentation. As you can see there, we've got the Doing Responsible Business in Armed Conflict guide and 7 indicators framework, which I'll explain in more detail. But what I would like to show you just very quickly is a sneak peek of an interactive training exercise that we recently launched. We developed this simulation really in an attempt to inspire the next generation of business leaders. So to answer a question that we kept asking ourselves, which was, how do we teach the laws of war to the next generation of corporate leaders and decision makers? So the future engineer working on the latest weapon designs, or tomorrow's mining CEO that's about to invest in African cobalt. So if you indulge us for just a minute and a half, I'll play this for you.
Take on the role of CEO of a multinational company in this interactive scenario brought to you by Australian Red Cross and RMIT University. The increasing number of conflicts around the world and the expansion of global markets and supply chains into these complex environments has created a real and present concern for the private sector. When a crisis occurs, a company needs to be prepared to make effective decisions under pressure. In places experiencing armed conflict and war, companies have a responsibility to ensure they understand and uphold the fundamental laws of war. This short course is designed to prepare future business leaders to tackle the unique challenges that arise under international humanitarian law in conflict zones.
We start our bulletin with breaking news.
Is it more than a human rights violation?
Somebody started shooting. We don't know if it was the BAF or our private security.
In this interactive experience, you will be confronted with challenging questions that could impact the fate of your business, your staff, and the local community. You'll gain access to tools and frameworks that can help shape corporate policy and practice, and you'll learn from experts, consult with a team, and discover how international humanitarian law can help you navigate a crisis. Prepare yourself to be the leader the business world needs. It's up to you, CEO.
So there you have it. It's, I think, although I am biased, a very engaging introduction to the intersection between responsible business practice and management and the laws of war. The module's live on our website and it's free for anyone to complete, and we'll include a few links in the chat and later in the presentation for those that are interested. We'd love if you'd consider doing the training. We'd love to hear feedback. Please share it widely with your networks, and if there are any academics among us, you're very welcome to embed it into your courses if it's of interest, and we can provide a sort of educator's toolkit that can help with that. But for now, let me pass over to Jonathan, and I'll come back to you shortly.
Thank you, and hello. I just wanted to add my 2 cents of welcome and appreciation to Stephanie, to Sophie, and to the CIPD and Queens. Thank you very much for the opportunity to share stuff that we are working on, that we're passionate about, and that I know there is some crossover also with your interests too. So I hope onwards and upwards for the relationship. Also just wanted to acknowledge that I am beaming in from the not so isolated, but just as beautiful part of Australia called Melbourne, and wanted to acknowledge the Bunurong people of the Kulin Nation, who are the traditional custodians of this land that I am zooming in from. Okay, let's get right back into it and pick up where Fauve and also Sophie's introduction left off, about just setting up the building blocks, if you will, so we can get in perhaps into a deeper conversation about businesses' rights, risks and responsibilities under international humanitarian law. I'm conscious that there might be a few lawyers, political scientists, and all sorts of other disciplines in the room. So forgive me if I have pitched this too low or too high. We can certainly answer any questions and look forward to the engagement in Q&A. International humanitarian law is not human rights law. International humanitarian law actually predates international human rights law. International humanitarian law, otherwise known as IHL or laws of war or laws of armed conflict, actually dates from the 1800s. The mid-1800s saw the US Civil War, as well as some very violent wars on the European continent that led to the thinking that there should be limits to warfare. There were some important developments in America at the time. The Lieber Code in particular is what I'm thinking of. But Henri Dunant, a businessman, I should add, stumbled upon a very violent battle in the mid-1800s, a battle of Solferino, and saw the suffering of the injured troops on the battlefield the evening after the battle. And he said, there's got to be a better way to care for these injured and dying soldiers. And he went back to Geneva, where he called home, and founded, together with some of his colleagues, the International Committee of the Red Cross. The International Committee of the Red Cross dates from the 1860s. There have been numerous international treaties, conventions, and an elaboration of IHL since then. Human rights law, on the other hand, really only, stems from the Enlightenment, from US Declaration of Independence, French Declaration on the Rights of Man, but really international human rights law, as we know it today, only got going after the founding of the United Nations, after 1945, including with the landmark achievement of the Universal Declaration of Human Rights in 1948. IHL, as opposed to human rights law, only applies to situations of armed conflict. It is the specialized area of international law that regulates behavior in situations and times of war. It has, if you will, 2 objectives. One, to protect civilians, to protect people who are not participating in hostilities. And 2, to limit the means and methods of warfare. So nuclear weapons, chemical weapons, landmines, cluster munitions are all banned under IHL conventions. Perhaps at its core, IHL is most famous for the 4 Geneva Conventions of 1949. There's some additional protocols that are rather important from a legal perspective, but the Geneva Conventions of 1949 lie at the heart of IHL. Ooh, trying to click forward. Oh, there we go. And for the better part of the 150 odd years of its existence, IHL and the Red Cross's work in disseminating and educating the world about IHL has been directed towards militaries, towards governments, towards the actors that are actually engaged in warfare. We can talk about why and historically, but IHL is also relevant to businesses today. As Sophie noted, there are increasing number of multinational companies that have direct operations and countless thousands, perhaps millions more businesses that have supply chains, that have customers, that have stakeholders that are in conflict-affected areas. So the significance of IHL to business can be measured just in the terms of numbers of businesses with supply chains or operations in conflict-affected areas. And importantly, a distinction between IHL and human rights law is that IHL applies to everybody whose activities are closely linked to an armed conflict. Built into the law is an audience of non-state actors, whereas human rights law is directed at governments, at states' responsibilities to protect our human rights. And so what we are trying to bring to light is that there are also increasing risks to businesses and to the communities in which they operate, where if a business fails to act and comply with the provisions of international humanitarian law. Risks and consequences for the business, but also for those communities. So there could be an increase in risk of armed conflict, a flare-up of fighting. There could be genuine risk, even loss of life to community members around business operations and supply chains. And indeed, there are risks to business themselves as well. Their personnel, their property, their assets, their bottom line, as well as their reputation if they fail to comply with IHL provisions. There are, we like to say, three pillars of risks that businesses face: the legal, the operational, and the reputational. And we can unpack that. I believe Fauve will unpack that a little bit more in her remarks as well. But let's also not shy away from the fact that IHL's mission is to protect civilians, and aside from that business risk, the risk to business, there is a profound human risk if businesses, such large social, political, and economic actors, especially in many conflict-affected areas, fails to heed and appreciate the significance of IHL. There's been in recent years a crystallization, if you will, of that risk to business. And perhaps the message and the way that the entry point that Fauve and I have had with many businesses, both Australian and foreign, that we have spoken to over the last few years, that have pricked up their ears and sit up a bit straighter in their seats when we talk to them about, preach to them about the value of IHL to their business, is the fact that some of their colleagues are now being prosecuted, criminally prosecuted, not for human rights violations per se, but for violations of international humanitarian law, war crimes. In fact, the label war crimes is something that is unique to and attaches to violations of international humanitarian law. So I just wanted to give you a quick snapshot. Lundin Oil, this is a very well-known company in Sweden. It's as if a BHP or a Rio Tinto in Australia. I'm not sure the equivalent of that well-known Canadian brand, but Lundin Oil, as it was then known, changed its name to Lundin Oil. I believe now it's referred to as Lundin Energy. This is the chairman and former CEO, Alex Schneiter and Ian Lundin. They are being prosecuted for war crimes by a Swedish prosecutor in a Swedish court. We've all heard of President Omar al-Bashir, the former leader of Sudan. During the Second Sudanese Civil War in the late 1990s, early 2000s, Lundin wanted security for one of its lucrative oil exploration sites in what was then South Sudan, Southern Sudan, excuse me, not the now sovereign state of South Sudan. They knew, or ought to have known, that the military that Bashir sent and the militias that Bashir sent to secure that oil site were doing so via nefarious purposes, including the commission of grave war crimes against the civilian population. The company has been maybe subject to fine and a forfeiture of the benefits of them selling that oil exploration site. And these two white-collar business people may find themselves in jail because of failing to heed IHL. Another example that has actually found a businessman behind bars is the 2004 case of a Dutch businessman who was investigated, prosecuted, and found guilty of complicity in war crimes, the war crimes of the Saddam Hussein regime. It was Frans van Anderaat that supplied chemical precursors to build the chemical weapons that gassed the Kurds in the 1980s by Saddam's forces. He was found guilty and is imprisoned for 17 years. It's these stories of personal, individual criminal prosecution for failing to heed IHL that have resonance in the C-suite. I should also just add that when we go back and have a look historically about the development of international humanitarian law, human rights law, and international criminal law, Nuremberg looms large. We often forget it wasn't just Nazi political and military leaders that were prosecuted at Nuremberg, but also corporate leaders of Nazi Germany. Over 24 Nazi German corporate leaders were prosecuted for war crimes, including the selling of the Zyklon B to the Nazi concentration camps and the use of forced labor in those camps as well. Fast forward to the other side of the picture, which is, and I'll 5-minute warning, Fauve. Increasingly, since around about the 2000s, there has been growing awareness that businesses have more social responsibilities than merely making profit, as Milton Friedman once famously said, Nobel Prize-winning economist. And increasingly, the discourse around CSR, or company social responsibilities, has transformed into a dialogue around businesses' human rights responsibilities. And this really is the dominant discourse these days around CSR, around a company's social responsibilities. And what is on your screen now is what's called the Ruggy Framework, or the Protect, Respect, Remedy Framework, that was developed by Professor John Ruggy in 2008 and then elaborated upon in what's called the UN Guiding Principles on Business and Human Rights. It states that states must protect human rights, companies should respect human rights, and all victims of corporate human rights abuses should have access to remedy. This is the dominant discourse around companies' social responsibilities. It is the language spoken by civil society, by academia, and most importantly, by the sustainability advisors and lawyers in these in many major multinational companies, and even smaller ones too. In fact, it is so popular that it has been embedded in a variety of different governance instruments, and the cues that John Ruggy has put in the UN Guiding Principles have actually been adopted by governments. So the Guiding Principles say that a company should conduct what's called human rights due diligence. Nowadays, many governments around the world, including Australia, including the UK, we can chit-chat about Canada if you wish, have mandated that companies report about their human rights impacts throughout their entire global supply chains. Many standard setting ESG style standards also now incorporate human rights as a key plank. But what we discovered to our surprise is that these instruments, these BHR, business and human rights instruments, whilst many of them do acknowledge the existence of international humanitarian law, they do so in a very oblique manner, or not at all. A very shallow understanding and appreciation of how to integrate international humanitarian law into the business and human rights governance instruments. And this is so perhaps for a variety of reasons. But what's more stark is that the guiding principles themselves actually say that a focus of attention in business and human rights should be conflict-affected areas, because that's where the gravest human rights abuses occur. So it's a little surprising, therefore, that the treatment of IHL is not where we would like it to be. In either the UN Guiding Principles, the OECD Guidelines for Multinational Enterprises, and even instruments such as the Voluntary Principles and Queen's University's own conflict prevention tool, are incredibly valuable instruments that target the governance of companies and improve companies' behaviour in conflict zones. But we would submit room for improvement in how they integrate IHL into those governance frameworks. And on that note, I think I'm going to hand over to Fauve.
Thanks, Jonathan. I think I've got control back of the screen, so that's great. So I suppose at this point, it's helpful to dive a little deeper into the detail of how IHL actually applies to businesses or is relevant to businesses in the legal sense. It's, as Jonathan discussed, the fact that IHL is referenced doesn't mean that there's sort of that guidance or implementation guidance around what it means to actually integrate and fulfill those responsibilities under IHL. And it's probably a good point at this stage to just refocus our energies on why that is important and why IHL is and should be mentioned in the first place. So I'm just sort of briefly going to mention 4 kind of key categories. The first really revolves around the protection of people. So IHL really protects anyone who's not or no longer participating in the fighting. So you've got your civilians, humanitarian workers, medical and religious military personnel, prisoners of war, and of course, wounded and sick soldiers. And people in these categories are will benefit from certain protections under IHL because they are civilians. It's no different for business personnel, including local and expatriate personnel, contractors and consultants. They all benefit from these same protections because they are civilians. But it is important to note that businesses should ensure that beyond self-defense, personnel know not to engage in the hostilities or in the conflict activity. These actions could be seen as direct participation in hostilities or DPH, and this is really a notion or a concept that's quite unique to IHL. So yes, there's an inherent protection element here, but there's also an expectation that companies train and inform their personnel accordingly. Similarly, civilian objects such as homes and hospitals and schools, they're also protected from attack under IHL. This, of course, includes business assets, investments, and property. Again, though, there is that risk that protection, that civilian status could potentially be lost or sort of waived if that property is used for a military purpose. So if you take, for example, a business with manufacturing facilities in a country that is experiencing conflict, if that business produces ammunition, for instance, that's then used by a party to the conflict, then it's likely that that munitions factory would become a legitimate military target, as would any trucks or planes that are used to transport that ammunition to the front line. Similarly, if a private oil pipeline carries oil that's transferred to and used by a party to the conflict for military operations, it can also become a legitimate military target. On the other hand, if a manufacturing business or any other business sells products or services that aren't contributing to military action, it doesn't become a legitimate military target unless, of course, those premises are used for a military purpose. So again, there's that protection that's built in through IHL for businesses' property, but there's also that corresponding responsibility to ensure that property is not used improperly. IHL also extends responsibilities and obligations on any actor whose activities are closely linked to an armed conflict, including businesses. A couple I've outlined just now, but understanding what closely linked to an armed conflict means is really not an easy task. There's certainly no comprehensive list of what businesses can and cannot do, but where business personnel are sort of actively or directly participating in hostilities, or even inadvertently caught up in conflict, it's fundamental that they understand the rules and principles of IHL, because they'll most likely be bound by those obligations and responsibilities that then flow from IHL if they find themselves in that sort of conflict setting or contributing to that conflict setting. So it's likely that a business providing direct support, be it military, logistical, financial, to one warring party will find its activities are closely linked. And a clear example of this would be personnel that are fighting in the conflict, or a company, for instance, that's involved in exploiting natural resources, which are then used to further the war effort. Where this is much more difficult to determine, where that grey area is where the person is indirectly linked to conflict. So this is really where companies should be interrogating supply lines, partners and subsidiaries. It sort of goes beyond that immediate and direct contribution. And then finally, IHL also prohibits the confiscation of private property. Looting can be a very real risk in situations of armed conflict, but IHL does stipulate that private property must be respected, and this includes business premises and investments. Though it is important for companies to note that in limited circumstances of occupation, IHL can allow the occupying power to seize property of a business in certain circumstances, but really beyond this, the unlawful taking or appropriation of property and assets is something that can amount to pillage, which is a war crime and which we'll look at in just a moment. There we go. So just in terms of practical application, there are a number of unique challenges that businesses face, or scenarios, I suppose, that could arise from businesses operating in conflict zones. Again, this is some of what differentiates the importance of IHL from human rights law. I'll briefly mention three, but if anyone is particularly interested in unpacking more of these, they're outlined in more detail in some of the publications I'll mention in a moment. So the first relates to security practices. Unsurprisingly, the use of private security personnel is quite common for businesses that are operating in complex environments, conflict-affected and conflict-prone environments. These employees and contractors are often armed. They're sort of given this right of self-defense in order to fulfill their contractual obligations. But as a result of that, they often, well, at least the risk of being drawn into surrounding conflict can be much higher. And this can certainly have ramifications for their civilian status and for the civilian status of the property that they've been hired to protect. So firstly, a company and its employees really need to be aware that they may be exposed to criminal liability if they're linked to the commission of a crime. This sort of makes sense. So lending personnel, logistical support, information, vehicles, weapons, companies generally understand this, we found, and they certainly prepare for this in a human rights sense, minimizing adverse human rights impacts in their human rights due diligence. So for example, providing human rights training to security personnel. What this often doesn't address though are the additional responsibilities that are triggered once an armed conflict exists. So one example being, as I mentioned earlier, this notion of direct participation in hostilities. So unpacking what the consequences for private personnel are if they do directly participate in hostilities. Another example often concerns use of force standards. So what degree of force can a security contractor, can or cannot a security contractor use or apply in any given situation? And this can really change depending on whether or not a conflict exists. And a good example of this would be the legality of certain weapons that are used by police in protests and riots versus what can be used in armed conflict situations. Pillage certainly sounds archaic. It doesn't seem like it should be a modern day term, but it sort of technically occurs when someone takes property from a legitimate owner for their own private and personal use without consent in an armed conflict. And in this context, the definition of property also extends to natural resources. So this means that a business that's found to be illegally exploiting such resources or purchasing illegally acquired resources could also be held accountable under this war crime. As Jonathan mentioned earlier, after World War II, a number of corporate officials were convicted of pillaging goods from Nazi-occupied territory to support the German war effort. Circumstances are certainly different today, but the risk of committing this crime certainly still exists in areas that are affected by conflict or occupation. So examples of this could include when a business has a sort of transactional relationship with an armed group that is responsible for the exploitation of property, or when property is acquired by a business without valid consent. So this latter risk in particular increases when a conflict concerns territorial disputes. So when there's a question about which authority ownership in the property vests, and this question certainly varies across jurisdictions. And then finally, IHL applies not only to active fighting, but also to situations where one party occupies the territory of another. This is known as military or belligerent occupation. So think, for example, the Israeli occupied Palestinian territories or the occupation of Crimea by Russia. In these contexts, there are significant legal and operational risks to be aware of. Activities like settling civilians in occupied territory, developing or expanding settlements, appropriating resources, as I mentioned, or damaging land or property can all constitute war crimes. So the actions of public and private security forces, or really, I suppose, any corporate personnel in these contexts, should really be analysed very carefully. So as I mentioned a little earlier, the current conflict in Ukraine really presents significant humanitarian concerns and IHL related issues, which we won't go into detail today, but the conflict does highlight how important it is for businesses to deepen their understanding and implementation of IHL before violence breaks out, before conflict erupts. So at the moment, there's an international armed conflict taking place in Ukraine. There's also a non-international armed conflict taking place that has been taking place in the eastern parts of Ukraine, as well as the military occupation of Crimea. So, you know, these multiple situations, evolving situations, really mean that businesses and investors that are operating or investing in the region, especially those that are in those higher at-risk sectors, such as weapons and finance and extractives, should be acutely aware of their risks and responsibilities. So this could look like the provision of weapons or military equipment to Russia, providing tech support, particularly in the event of cyber warfare, or purchasing natural resources from the Russian-occupied Crimea or Eastern Ukraine, or even perhaps paying a bribe to armed separatists to enable the continuation of one's business. So businesses are being called on to take a more conflict-sensitive approach and to conduct this heightened human rights due diligence that Jonathan spoke about, and in particular doing this by examining their links, particularly to Russia. But as we already know, the existing guidelines and disclosure standards just aren't sufficient to meet this expectation. But we would submit that you know, we've produced a couple of documents that would at least help to start this conversation. And included in this is our 7 indicators of corporate best practice in IHL, which we designed as a framework for any company whose activities or supply chains run through or could be anticipated to run through conflict zones. So the idea is really that companies can use this tool to supplement or enhance their existing business and human rights frameworks as a means of effectively implementing IHL. It's framed in a language that businesses understand, and we have tried to design it so that it's not burdensome. It simply adds value to the frameworks that businesses already have in place. So the framework's essentially divided into 4 umbrella categories, as you can see, of policy, capacity and capability, operations, and transparency and accountability. And under each of these categories sit 7 clear directives, as well as accompanying questions to consider and examples of best practice that can help spark discussion about the implementation and operationalization of IHL. Our other key resource is a practical guide for companies on doing responsible business in armed conflict. It builds on an earlier iteration or introduction to business in IHL, I suppose, that was published by the International Committee of the Red Cross in 2006. It's really an introduction. It's a first point of reference for businesses to IHL as a legal framework, and it explores a range of introductory issues that we've started to touch on today. So the principles and standards of IHL, its relevance to business, a bit of a snapshot of those rights, responsibilities, and risks, and some of those differences between human rights law and IHL that Jonathan mentioned. So these are all available on our website. If you're interested in looking into the detail of this and some of the things we've discussed today, we'll put the link for that up in a moment. So just to conclude, I just wanted to wrap up to say, I think we are seeing a growing commitment from businesses to conduct their activities in a more conflict sensitive manner. For example, through the UN Guiding Principles on Business and Human Rights. There's also this growing acknowledgement of the positive and negative impacts that businesses can have on conflict affected communities. So for instance, there are, examples of businesses that are playing a significant social or political or economic role. But there's also evidence of businesses that are profiting from, benefiting from, or in the worst case scenario, complicit in atrocities. We are actively continuing to actively work with Australian businesses to improve their understanding of IHL, their application of IHL. We've had some significant wins in the last couple of years, and I think we're both feeling quite encouraged by the change we're starting to see in the sector already. But certainly much more needs to be done in order to ensure that at the end of the day, protections for local communities that are impacted by war and its intersection with business are alleviated or the protections are upheld as much as possible. And this really starts with ensuring that businesses uphold their responsibilities under IHL. So some of our details up on the screen. You're very welcome to contact either Jonathan or myself, both of us. A couple of links, as I mentioned, the online Business and IHL Hub, which hosts all of our resources, and the interactive module that we showed you earlier up on the screen there as well. So thank you very much for your time, and I'll pass back over to Stephanie.
Thank you so much, Fauve and Jonathan. Very clear and structured presentation, easy to follow, yet very rich in terms of the details and examples that you've provided. While we wait for folks to ask some questions using the chat box, I have some questions of my own that I'll submit for your consideration, and feel free to address whichever one speaks to you. But the first one is on compliance. And of course, you mentioned Russia in your introductory remarks, and it came up again later in your presentation. It's quite disheartening when you see a member of the P5 at the UN openly flouting the laws of armed conflict. Certainly, we can point to other examples like the US and their continued use of landmines despite IHL conventions. And to me, that sparks a bigger question about variation in IHL compliance, not only across states, but across different types of actors. And so I wanted to ask you, what increases compliance and respect for international humanitarian law? And does it vary when you look at states, businesses, militaries? We would expect it to vary to a certain degree, but I suppose that there are some broader measures that can be introduced that can increase compliance and awareness across the board. So that's the first question. A second question that I had was with regards to the business case for IHL. Like, what do you need to say to get a CEO's attention? And I was kind of struck by the fact that, you know, what resonates most is this question of criminal liability. Like, that's a pretty high threshold. So I'm wondering, like, what other things resonate and what types of strategies do you resort to highlight the importance of IHL beyond this ideas that, you know, if you don't follow this, you'll get prosecuted for war crimes. So just another question there, because that's always a difficult balance to strike. You know, what will get you in the door to present your materials and resources, but you still need to get folks interested in that first 30-second pitch, if you will. And final question is, you know, I know there's a proliferation of tools out there for businesses when it comes to best practices in security and human rights. And you mentioned the Queen's tool specifically. And so while I have you here, I would ask you, what would you like to see in a tool like that so that IHL is better represented? Do you want like cross references to the tools that you have developed on businesses in IHL? Is it a text box that highlights something like the unique challenges that you have in your slides that you represented? So I'm just curious, because a lot of these tools are living documents and they continue to improve through the involvement and feedback of the broader community of practice. So I'm wondering, in your mind, what does it look like in those very short, succinct, practical tools? What would you like to see? More cross-referencing or something more substantive and something more specific? So those are my three questions. Maybe I'll look at Sophie quickly to see if she has any questions to throw in. And then, and so feel free to unmute yourself, Sophie, and just dive right in if you do.
No, actually, I've seen there were a few questions in the Q&A, so I'm very interested. And I have to say the business case was the one that I was having. So I would like to hear you on that, but I think it's already a very rich discussion. So by all means, you can go ahead with answer, and that will still be very, very useful. Thank you.
Perfect. Thank you, Sophie. And I'll go ahead and collect these two questions that popped up so that you've got a menu of questions to choose from so we can maximize the time that we have left in the session. Okay, so we have a question from Sonia, and she's asking, are territories where illegal mining is practiced and where there are armed groups but not separatists from the state considered territories applicable to IHL? And then David Richard Carl asks, what is the enforcement body that prosecutes violations of IHL? So we've got two very fact-based questions that you can address, and then the three other questions that I posed, which you can answer now or later at your convenience. But let me turn it over to you and for the 6 minutes or so that we have left.
Wonderful.
Fauve,
what rich questions.
Yeah, let's divvy this up. You take the hard ones and I'll take.
Fair enough. It's usually goes the other way. So that's only fair, Jonathan. No, terrific questions. Thank you so much. There's so much to think about and unpack there. Perhaps if I start with your first question, Stephanie, about what increases compliance and respect. I think if I had the answer to that, I probably would be paid a lot more than I am. I'd be in a different position to what I am. No, jokes aside though, I think, and maybe I'll answer this sort of in parallel with your other question around the business case for IHL and using that criminal liability piece as a bit of an elevator pitch. I think the element of criminal prosecution really can't be understated. So I know that it's very different in terms of militaries and governments, but at least our experience with the business world, in the first year or two of our work, criminal prosecution was not something that pricked the ears up of CEOs. The threshold to meet is so high, and the risk of that happening in Australia at least is so low that it didn't sit high on the list of priorities for companies. Since then, we've seen a couple of cases like Lafarge, like London, where domestic courts are using their own jurisdiction to prosecute, their own companies for these international crimes. And I think that, and the parallel that has with the Australian Criminal Code, which essentially embeds the Rome Statute of the International Criminal Court, and so can prosecute for things like war crimes, has started to gain much more traction. This concept of universal jurisdiction is something that companies are now much more interested in. And so I think that this, as a motivator, does have has legs more than it ever did. I'd also say that it's not just a criminal or even civil liability risk issue, but it's very much about ethics as well. Companies are very conscious of their reputations, and it's not necessarily, and their bottom line, but it's not necessarily a legal issue. It's so often an ethical issue, and we've even seen that in I don't know if this has reached Canadian shores, but well, I'm sure it has, but we had a report come out a couple of years ago around the actions of our special forces in Afghanistan, the Brereton report, and one of the findings from within the Brereton report stated that it's less to do with the rules of engagement and understanding of what the rules of engagement are, and more to do with the ethics, more to do with, how do you encourage troops to act in a certain way? They know what the rules are, but how do you encourage that action? And I think it's a little bit of that as well. So it's the legal and the ethical coming together. If I could just, before I hand over to Jonathan, I might just also just touch on the proliferation of tools question that you had, and what do we want to see? I think we talk a lot about, yes, there's reference to IHL, but not this sort of detailed implementation. And what more than, certainly we would love to see our products being used either as implementation tools or as conversation starters. But I think more than anything, what we'd like to see is companies really taking that reference to IHL and unpacking what that means practically. So for instance, even the Voluntary Principles Initiative, which goes into quite a bit of detail in its recent 10 steps guide, 10 steps tool, I think they call it, unpacks IHL or talks about IHL much more than any other document I've seen. But even then, when you talk about, one of the steps is implement IHL training, or, I'm paraphrasing, but implement IHL training where it's relevant. The training materials that are available on the Voluntary Principle Initiative's website are very human rights dominated, and more often than not, references to IHL are superficial and not sort of detailed to the degree that we'd probably want to see. But sorry, let me hand over to Jonathan. I know I've got an eye on time.
Very quickly, let me just add a few things and try not to repeat. Thank you for those questions. They keep us up at night. Don't think that we have the answers per se. So in terms of, let me answer them very quickly in perhaps different ways. What increases compliance with IHL? Well, let me submit to you that leveraging the power of business is one way that we as society, as a global community, can also increase awareness and compliance with international humanitarian law. If you think about it simply in terms of who has capacity and resources in our society and in situations of armed conflict, it's actually quite foolish to not engage businesses on IHL issues. In terms of the business case for IHL, agree, it's complicated. There are some really interesting non-legal mechanisms right now. You guys in Canada have 2 private members bills to give more teeth to a mining ombudsperson at the moment. You have also what's called the OECD National Contact Point, which, because of a bit more of agitation from NGOs, is increasingly being used by corporate human rights abuse victims. It's free and no charge, and is no one wants to be the defendant, so to speak, in an OECD national contact point complaint. The other point about the business case is it's always cost benefit, right? With and assessing the risks versus the reward. The reward is great, I would suggest, in terms of protection of personnel, property, assets, reputation. And that's the one thing that IHL also provides, which we try and convey, is protection. IHL is not just asking companies to do stuff. IHL also gives companies valuable legal protections in conflict zones. And that's part of our message. The other part of the message is the cost is not a whole lot. Most of these major companies are already doing some version of human rights risk assessments, conflict sensitivity training. Again, I just want to commend Queen's University and the ICRC on their conflict prevention tool. It's fantastic. Integrating IHL into those types of preventative measures is very low cost. We provide our training materials for free, for example, and the websites are in the chat. So start there. And then in terms of embedding IHL into the tools, look, Stephanie, to be honest, I'm frustrated, exhausted, bemused, shake my head at the proliferation of tools. We need to do something collectively about it. There are so many conversations that Fauve and I have had where we've been asked, so which one do we use? So we, as concerned citizens that are producing these types of resources, I think we absolutely need to do a better job of communicating, collaborating, and, as you say, cross-referencing and really providing, if you will, an easy, accessible way for companies to do good in conflict zones.
Wow, well, you two are definitely the dream team. Very well done with the questions. And I do wish we had more time, but we'll have to wrap up. So let me thank you both for an incredibly interesting presentation. We've had lots of presentation this year on defense policy. So this is a nice change of pace, although, the overlap is clearly visible, when it comes to IHL. And so definitely of interest to our community of scholars and practitioners here at the CIDP. I also want to thank my co-moderators, Sophie Rondeau. Thank you for doing this with me today. And to all of those in attendance today, I just want to specify that this is a recorded session. And so we'll have this online shortly if you want to share this presentation. So anyone who wants to watch asynchronously can view the presentation and also perhaps embed it in their teaching or research activities. Thanks again. Take care, everyone, and we'll see you soon.
Thank you so much. Thanks for having us.